So did Kyle Rittenhouse act in self-defense or did he not? Let's talk about this. But real quick before we jump into this video, I want to thank a couple of our sponsors, the first being Thorson Customs. Thorson Customs does a lot for this channel and a lot for California gun owners. They have California compliant parts and features that you go and purchase from them. And the other company that does a lot to support this channel is Got Your Six. For just $2.99 a month, you get access to a lot of amazing things on their app, which is geared specifically towards firearms owners. So if you'd be interested in taking a look at either of these companies, I'll put links to both of them down in the detail section. So this video topic is one of the most requested videos that I've ever been getting, especially since this all broke out. And the issue and the question is whether or not Kyle Rittenhouse acted in self-defense or not. And this is one of those issues that within the 2A community, within the gun community, there seems to be a sentiment that leans heavily in one direction towards him acting in self-defense, but there's still some individuals within the gun community, within the 2A community, who do not believe that he acted in self-defense, instead that he actually did commit some sort of murder of these other individuals. So let's talk about this, and I'm gonna take a look at some of the Wisconsin codes that deal with this issue. We're gonna talk a little bit through this. Now, full disclaimer, although I am a licensed and practicing attorney in the state of California, I don't have any specialized expertise in Wisconsin law or anything like that. This is just my opinion based on looking at the Wisconsin laws, statutes, and based on what I've seen, the video evidence, some of the witness testimonies, reading through the complaint and things like that. This is the conclusion that I've come to. So let's get into this. So first and foremost, the Wisconsin statute that this is all going to revolve around likely is going to be a Wisconsin statute 940.05, and that is the second-degree intentional homicide. So the question is whether or not Kyle Rittenhouse committed some sort of intentional homicide of these individuals that were shot during the whole Kenosha, Wisconsin incident. And that section reads that whoever causes the death of another human being with the intent to kill that person or another is guilty of a Class B felony. So that is potentially what Kyle Rittenhouse is up against, is a Class B felony because there's an intentional homicide of some other individuals. Now, to rebut that and to rebut any other charges of some sort of intentional homicide, this whole case is going to revolve around an affirmative defense, and the affirmative defense is going to be self-defense, whether or not Kyle Rittenhouse, based on the circumstances, acted in self-defense. And so the Wisconsin statute that deals with self-defense says that a person is privileged to threaten or intentionally use force against another for the purposes of preventing or terminating what the person reasonably believes to be an unlawful interference with his or her person by such other person. The actor may intentionally use only such force or threat thereof as the actor reasonably believes is necessary to prevent or terminate the interference. The actor may not intentionally use force which is intended or likely to cause death or great bodily harm unless the actor reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or herself. So what does that whole statute mean? I mean, I read you all that legal mumbo jumbo, but what does this boil down to? First and foremost, an individual is allowed to use force to stop the unlawful interference of someone else on themselves. So essentially, if someone is trying to do something unlawful to you, use some sort of force against you, you are permitted to use force against them as well. And you're allowed to use force that you reasonably believe is necessary to stop that threat or unlawful interference on yourself. So you're allowed to use that reasonable amount of force. So it's kind of that proportionality. If you're familiar with California laws, I've done a whole video on California self-defense laws, and if you want to watch that, you can click that tab right there. But this kind of goes down to proportionality. You're allowed to use the force that you reasonably believe is necessary and is proportional to the threat in which you are receiving. And then it comes down to when are you allowed to use deadly force or very severe force against someone else. And that amounts to when you have a reasonable belief that you're in fear or there is some sort of great bodily injury that you may suffer, or there is potentially death that you may suffer from some other individual in the force that you are being presented with. So again, like I mentioned, this whole issue of Kyle Rittenhouse, whether or not he acted in self-defense, is going to come down to primarily that affirmative defense of self-defense, whether or not he meets those standards within that language. Now, there is some additional nuance to this. So first, that nuance comes down to a reasonable belief. You hear a reasonable belief, but what does that mean? There's legal jargon and there's whole law school classes that talk about a reasonable person, and that's really what it amounts to, is this objective standard, whether a reasonable person, just the average individual within Kyle Rittenhouse's shoes, in his circumstances, would they believe the force that he used was necessary when being faced with those types of threats he was being faced with? It comes down to that reasonable belief and that reasonable person. In those circumstances, would they do the same thing? And would they believe that type of force in using an AR-15 in self-defense would be necessary to stop that great bodily injury or death? And so let's look a little bit at those factual scenarios and nuances that go to whether a reasonable person would have a reasonable belief that they needed to use that type of force. First and foremost, in that first instance, he was being chased by an individual who threw something at him. Some people are saying that maybe it was just a plastic bag. Some individuals are saying it was a Molotov cocktail, but he was being chased initially by someone. So he wasn't the aggressor. Someone else was the aggressor. They were chasing him. He ultimately got cornered. And then reports are that the individual, Rosenbaum, actually grabbed the barrel of his rifle and was trying to take it from him. And that is when Kyle actually shot Rosenbaum. So I think it's hard to argue that a reasonable person, now again, it's an objective standard. Would someone, a reasonable person in that situation, believe that they are in fear of great bodily injury or death? And I think in that situation, yes, a reasonable person would have that fear. Then let's go to the next scenario where after Rosenbaum is shot, Kyle is seen, he kind of circles around the car, then he's standing over him, he makes a call, who knows who he's making the call to, and then he starts to run away. And as he's running away, individuals start to pursue him. There's individuals that are yelling that he shot someone to get him. One individual strikes him, then kind of disappears into the crowd, and then ultimately Kyle trips and falls to the ground. And when he trips and falls to the ground, then one individual tries to kick him. Another individual comes and tries to hit him on the head with his skateboard. And then another individual who has a gun kind of approaches him and then backs away. And during this whole circumstance, Kyle actually shoots a few of these individuals. So in this situation, would a reasonable person in Kyle's situation have a reasonable belief that they needed to use some sort of deadly force to protect themselves? And again, this is an objective standard. Would an objective, reasonable person in that situation, being chased by individuals, falling to the ground, then being hit with the skateboard, drop kicked, and then having an individual presenting a handgun to him and then try to go after him, would a reasonable person in that situation believe that they needed to use some sort of deadly force to protect themselves, especially when they're faced by more than one aggressor? Now again, this goes to this whole reasonable belief. There is a disparity of force that Kyle was presented with. He is one lone individual versus multiple individuals who are going after him. So again, objectively, would someone in that situation believe that they needed to use reasonable force or deadly force? In my opinion, yes. I think it's a hard argument to get over that someone in that situation did not have a reasonable belief that they needed to use some sort of deadly force. Now, along those lines, there's a couple narratives that I kind of want to clear up because there's some discussions that have popped up around the Kyle Rittenhouse situation that go to the whole self-defense aspect. The first one is, well, he doesn't have a right to use deadly force to protect property. And that is true. Under the Wisconsin statute, you are not allowed to use deadly force to protect property. But in my opinion, that is not what Kyle was doing in those two situations. Yes, he was there in Kenosha trying to protect individuals as businesses as well. But in those situations where he was being attacked by Rosenbaum, when he was being chased by the multiple other individuals and ultimately had to deploy his weapon, he was not protecting property in that instance. He was actually protecting himself. The next issue that pops up a lot in this discussion is a duty to retreat. A lot of people said, well, Kyle should have just gone away. He should have just ran away from the situation. He should have just found somewhere else instead of shooting. He should have just taken his beating and kept running. And under the Wisconsin statute, and specifically Wisconsin statute 939.48, subsection AR, you do not have a duty to retreat in Wisconsin. There are some states where you do have a duty to retreat, where you must actually try to flee or get away from the situation if you can, before you can act in self-defense potentially. But in Wisconsin, there is not this duty to retreat. And actually, if you read that section, it says that a court cannot use your ability to flee or to retreat against you. And along those lines, in that same subsection, it actually states that the court is supposed to presume that the individual reasonably believed that the force was necessary to prevent death or great bodily injury. So again, the court is actually supposed to presume that you acted out of fear of great bodily injury or death. And that is granted to you, and it is up to the prosecutor to rebut that once you raise that affirmative defense and once you put forward those facts. Now, the next two main ones where this is where there's that great divide, not only within the gun community, but also just with individuals who are liberals, progressives, and individuals who are conservatives, Republicans, things like that. This is kind of where that line is drawn, and it is on these two next issues. And it has to do with someone who's engaged in criminal activity or someone who actually has provoked the situation. So first, let's look at criminal activity. And this is going to be in that same statute, 939.48, and it's going to be subsection B1. And what it states is that the presumption described in subsection AR does not apply if the actor was engaged in a criminal activity or was using his or her dwelling, motor vehicle, or place of business to further criminal activity at the time. So again, like we just discussed, there's this presumption that is granted to you that you were in fear of great bodily injury or death. What this subsection is saying is that if you were engaged in some sort of criminal activity, you lose that presumption. So some individuals are trying to argue that because Kyle was there in possession of a rifle, he was 17, that he loses this presumption. And based on what I'm reading in this statute and based on looking at some of the additional discussions around this, the mere possession of a rifle does not seem like the legislative intent that was actually imported into this about when you're supposed to lose that presumption. Now, do I think that the prosecutor might try to use this subsection to kick Kyle out of the self-defense claim? Potentially, but again, I don't think that it's a very neat fit with the situation that Kyle was in. And along those lines, you actually also look at provocation. There is a section where if you're the initial aggressor or the actual individual who provoked the incident, you are potentially kicked out of the self-defense situation and the affirmative defense as well, unless some other things happen along the line. So let's talk about this. You can find this provocation section in 939.48. to subsection A, and this section talks all about an individual pretty much being the initial aggressor. And so this section says, a person who engages in unlawful conduct of a type likely to provoke others to attack him or her, and thereby does provoke an attack, is not entitled to claim the privilege of self-defense against such attack. So some individuals try to point to this section to say, well, Kyle actually provoked the individuals who attacked him. Now, does him just standing there with an AR-15 style rifle, is that unlawful conduct, the type that is likely to provoke other individuals? I think that's a very attenuated argument. Now again, will the prosecutor likely use that? Very likely that the prosecutor might try to use this argument, but again, I think it's very attenuated. Was him being there with an AR-15 style rifle, is that the type of unlawful conduct that is being contemplated in these statutes? In my opinion, no. And even in the situation where someone might be falling under this provocation language, let's say for hypothetical that Kyle was actually engaging in some sort of conduct that provoked other individuals. This subsection goes on to actually import some additional language that says even in those situations, potentially he could still be acting in self-defense. And what do those situations look like? Well, it looks like he is faced with some sort of deadly force. He then has to retreat because this kind of imports, unlike the normal situation, this statute imports a duty to retreat. So he tries to flee, he tries to get away, then he trips and falls. He has been trying to get away. In that situation, when he no longer can retreat, all options are gone, he is then able to act in self-defense. And so based on all that legal mumbo jumbo that we just went through, based on looking at the Wisconsin statutes, based on the information that we have right now, as of December of 2020, my opinion is that Kyle did act in self-defense, and I think he has a valid argument and a valid affirmative defense of self-defense. I think he met those standards of being a reasonable person who reasonably believed that they were in fear of great bodily injury or death. I think based on all these situations that he was being presented with, there was that fear of great bodily injury or death. Again, you can't forget that it looks like he was being chased down by one individual, maybe even a Molotov cocktail was being thrown against him. He was cornered, the individual tried to take his weapon, therefore he deployed his weapon in that situation and shot that individual. Then he tried to flee. He was trying to get away after that situation. He was even calling someone to try to let them know that he actually had just engaged in that conduct, that he had just shot someone. In trying to get away, he's being chased down by multiple individuals. He then gets hit by one individual who kind of sneaks away into the crowd. Then Kyle falls. Then he is drop kicked by one individual when he shoots that individual. Then he is hit over the head with a skateboard. He shoots that individual. Then another individual actually has a handgun, and Kyle can clearly see the handgun. That individual stops, pauses for a moment. Kyle doesn't shoot. Then the individual rushes him, and then Kyle shoots. Based on all those factual situations, based on the information and videos that we have right now, I think Kyle does have a very solid claim for self-defense, and I believe that, based on my opinion, looking at everything, that he did act in self-defense. So I know a lot of you guys were asking me about my take on this. How do I view this situation, whether or not I think Kyle was justified in what he did or not? Did he act in self-defense? Again, based on everything that I've seen right now, based on looking at the Wisconsin statutes, I think Kyle did act in self-defense. But let me know what you guys think. I know everybody kind of sways and has varying opinions on these things, and let me know down below in the comment section whether or not you believe that he acted in self-defense or not. Also, one thing I think that all of this has really brought to light is that you need to have very good carry insurance if you are ever going to find yourself in one of these situations. I always recommend USCCA. USCCA is an amazing company. I've done a whole video of why I prefer USCCA on this channel, so I'll put a link to them down in the detail section if you guys want to take a look. So if you guys like this video and like to support the channel, one of the best ways to do that is to like, comment, subscribe, and make sure you hit that notification bell, because that helps the channel analytics, helps us spread the word about the Second Amendment, also spread the word about things like this that are going on in our nation. So as always, thanks guys for watching. Don't forget to like, subscribe, and never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.